Welcome everyone to Child Trafficking in Australia, the story of classification. Before we begin, I'd like to acknowledge the traditional custodians of the lands we're meeting on today. I'm joining from the lands of Wurundjeri Wurrung people, and I want to pay my respects to the elders past and present, as well as to any Aboriginal or Torres Strait Islander people joining us. I also want to acknowledge the heavy nature of what we'll be discussing today. Today's conversations touches on the traumatic legacy of the stolen generations and the ongoing harm caused by child sexual abuse, particularly in out-of-home care. We recognise the pain and injustice and also the strength of those who carry these stories. While we don't speak on behalf of anyone's lived experience, we come into this space with care and a commitment to listen, to learn and to do better. Today's content includes references to child sexual offences and trafficking. If anything we discuss feels distressing, please feel free to step away and take the time that you need. There's support available and your wellbeing is absolutely our priority. Throughout today's webinar, we invite you to be a part of the conversation. If you have a question, please feel free to type that into the Q&A box that should appear at the bottom or on the corner of your Zoom screen. We'll do our best to answer as many of those questions throughout this webinar. Firstly, I'd like to introduce our other two panelists, Gabby and David. So Gabrielle Fitzgibbon is a barrister practicing in criminal, public and administrative law. Before coming to the bar, she worked in the specialist trial prosecutions team at the Office of Public Prosecutions, and she brings a wealth of experience in complex criminal matters. Gabrielle co-authored the Child Trafficking in Australia, the Story of Classification report, and was a key contributor to ZOE Foundation Australia's submission to the Attorney General's targeted review of modern slavery offences. I also have with me David Cross, who's the CEO of ZOE Foundation Australia, and for over a decade he's been on the front lines, both here in Australia and overseas, working to prevent child trafficking, support survivors, and strengthen legal frameworks. His leadership spans everything from rescue operations to legislative reform, and like Gabrielle, David also played a major role in the Story of Classification report and ZOE's recent legal submissions. Together, they bring deep insight into both the systemic challenges and the human impact behind the data. We're incredibly fortunate to have both of them with us today. So David, before we get into the findings and legal gaps, I think it's really important to start with the basics.
Well, thank you, Woon. Good to see you, Gabby, and thank you to everyone for joining us today. I think, it's a good place to start if we just define what we're talking about today. So if we're talking about child trafficking, we'd be starting with Article A, the international definition, and looking at the protocol to prevent, suppress and punish trafficking in persons. And so when we look at that international definition, it kind of gets broken down into the act, the means and the purpose. So when we're talking about the purpose or the why is always exploitation. When we're looking at the act, we're looking at things such as recruitment, transport, transfer, harbouring or receipt of persons. And so we're looking specifically today at those natures relating to children. So when you're talking about children, you don't need to prove the means. When we bring that into Australia, into Australian law, we're talking about the Criminal Code. We're talking about Divisions 270 and 271. So 270 is looking at issues around slavery, slavery-like practices and forced marriage. We're looking at 271. We're looking at crimes around trafficking in persons. So today's discussion will centre really on 271.7, and that's specifically relating to the domestic trafficking of children, and that's what we'll be talking about today.
Well, there's a lot of numbers there.
Yeah.
Technicalities.
Yeah.
That's why we've got Gabby with us.
Yes, that's right. Yes, we brought a barrister to the meeting, so that'll help us both.
So from a legal and data perspective, what does it actually look like, domestic child trafficking in Australia, Gabby?
Yeah, so since the offence was introduced into law in July of 2005, there's only been one recorded conviction for child trafficking in Australia. So on the official numbers, it's only happened once.
So on the surface, the numbers might suggest that it isn't really happening. Yeah. So or that's incredibly rare. But clearly you saw something different, and that's why you look deeper into this issue. Can you tell us a bit more about that?
Yeah, so I think a slide's going to come up that shows a little bit of data. What that shows is that in Australia, the recorded instances of trafficking has been consistently increasing. Beyond that, what we know is that the United Nations Office on Drugs and Crime has said that since 2019, there has been a 31% increase in the number of child trafficking victims globally. We also know that 1 in 3 victims of trafficking is a child. And the United Nations has also recently observed that the recorded number of trafficking victims in high-income countries is increasing, and that includes Australia. So taking these things together, this is a pressing and urgent issue.
Yeah. So David, what led ZOE to create this paper? Was there a particular moment for you?
Yeah, so ZOE's been going since 2002. So my journey started with ZOE in 2010, and a lot of my experience initially was overseas. So I was working with our team in northern Thailand. Fast forward to 2021, we're living back in Australia, and we had a conversation with Kyla Rabi. At the time, she was the National Program Manager for the Australian Red Cross, and so she was in charge of the Support for Trafficked Peoples program. So when we had that conversation, we were asking about instances of cases domestically. So was this crime type being seen? What were they seeing? At the time and since the inception of the program, they were only aware of like 22 cases involving children outside of the issue of forced marriage. And so I guess that initial discussion started to have us both ask questions. Why were we not seeing more cases? Why were we not hearing about cases domestically? And the data that Gabby shared about 1 in every 3 victims globally being a child, why were we not seeing that same statistic mirrored in Australia? So it kind of started an initial conversation where the data wasn't kind of showing anything. So what we wanted to do is say, okay, well, how do we explore this further? So we worked with Dr. Narita, we worked with Gabrielle, worked with Anna, worked with Davina, and then we had another organisation, a legal firm, HWL Epsworth. They offered pro bono support to look at cases that have been tried through the criminal justice system and see if we could pull out elements within past cases that could have been trafficking. So that was happening on one side. At the same time, we were talking with people, meeting social workers, meeting people who are frontline workers, and they were kind of sharing anecdotal stories with us. And we were listening to these stories and going, wow, this looks and sounds like trafficking. And so we had these 2 parts. We felt like we needed more data to try and understand the problem. And then we were hearing the anecdotal. So I don't think any of us sat here and said, hey, 3 years from now, we'll be producing an organisational report like what we're doing today. But it kind of started. And once we started to investigate this more, we were like, okay, this needs some more rigorous investigation. And I think it's interesting timing because we just had the UN Special Rapporteur come to Australia, and she released her findings on her report in January 2025. And she said that that children and young people who have experienced exploitation for sexual purposes in Australia, so this is in Australia, many whom may have been victims of child trafficking and not being identified as such, even when the relevant indicators may be present. So I think it's interesting. We were learning, looking at data, hearing stories. Now we have the United Nations highlighting this issue. And I guess the purpose of the paper and our heartbeat behind this, and I hope I get this clear as we talk today, we never want to sit in a place that we're pointing fingers or blaming or looking at, oh, why isn't this happening? At ZOE, we're very solutions driven. So we want to be part of helping. And there's so many people who are on the call today that do incredible work and they work incredibly hard to try and advance and help children. So we really see this paper as a call to action to say, okay, could this be happening in our country? What does the data show? And I think ultimately our heartbeat is that every child would be seen, their story would be heard, and then ultimately they would get the care that they deserve to heal from trauma.
Wow. Well, it's incredible eye-opener for me, and I think it really comes down to awareness. So I spent 3.5 years in the sexual offences and child abuse investigation team in Melbourne, and we had over 500 cases a year. And just through my, few conversations with you, David, I'm starting to think back to those cases and go, how many of those could have fit the definition, the UN definition of child trafficking? And that thought blows my mind. Yeah. And so for those who haven't read the paper itself, what did you find?
Well, I'll give it to you in one line so that we can get into the legal dialogue. The one line takeaway, and I do want you to read the paper, but the one line is, it is happening here. It is happening here.
So, Gabby, when you say trafficking is happening in Australia, I think most people would assume it's children that's brought here from overseas. But is that what the paper is focused on, or are we talking about something else?
Yes, that does happen, children being brought here or taken away from here. This paper is about trafficking that's occurring in Australia. So it's domestic child trafficking that we're talking about. It's trafficking that's occurring within our borders to our children.
Yeah. Okay, so what did your research actually uncover?
Yeah, so what the research found is that there's cases in Australia that are being charged and prosecuted as something other than domestic child trafficking. So that is, we've got offenders who are being charged with an offence that is not child trafficking, despite the offending conduct meeting the criteria for child trafficking. So what we would typically see is some kind of substantive state-based offence. So we might have a sexual penetration of a child under 12 charge, a sexual penetration of a child under 16 charge, or some other kind of offence. We're seeing a lot of CAM charges, child abuse material charges, rather than offending conduct being charged as child trafficking. So what we've done in the paper is we've pulled out 5 case studies from across Australia. We've got case studies from Western Australia, Queensland, Tasmania, and New South Wales. And we say that these cases expose a national pattern, and that is that child trafficking is happening in Australia, but it is being hidden by an issue that we've termed misclassification.
So just to help us understand a little bit more in our context, can you walk us through one of those
Yeah,
cases?
of course. So in order to understand why we say these cases could be prosecuted and charged as child trafficking, we first need to get into a little bit of the law. The paper goes through in quite some detail about how a charge is brought and proved under the Commonwealth Criminal Code. For today's purposes, we'll keep it fairly general. In order for a person to be convicted or found guilty by a jury of child trafficking, two things need to be proved beyond reasonable doubt. The first are our physical elements. This is about what the offender did. It's about their conduct, it's about their actions. The second thing that we need to prove is the fault element. This is about what the offender's state of mind was. So here we're talking about things like intentional, recklessness, etc. So in order to secure a conviction for domestic child trafficking, we need to prove the physical and fault elements beyond reasonable doubt. The elements are contained within the offence or provision itself. So for the purposes of today's discussion, we're talking about section 271.7 of the Commonwealth Criminal Code, and that section has the physical and fault elements in there. Now, to complicate matters a little further, there's a third element that comes into play, and this is what's called the jurisdictional requirement. Now, the reason we have this third element is due to section 51 of the Australian Constitution, which puts limits on federal power. So we won't get into this too much for today's purposes, but what we know is that in order to secure a conviction, you need to prove the physical elements beyond reasonable doubt, the fault elements beyond reasonable doubt, and you need to have satisfied one of the jurisdictional requirements or criteria. So in the paper, we've used the 5 case studies and we've gone through each of the physical, fault and jurisdictional elements, and we've shown how these can, or parts of these can, be satisfied by the offending conduct in those cases. So if I get into a little bit of the detail about some of the cases, and this is where I will be discussing some of the detail. So if you find this content distressing, now might be a good time to step away. But maybe if we begin with case studies 1 and 2, which involved offending conduct that occurred in Tasmania. So in this case, we have a complainant who was 12 years old. She was the daughter of one of the offenders named Dell. The other offender was Dell's partner named Divine. And the arrangement really came about out of a desire to bring in cash. Divine began offering the complainant services via an advertisement placed in the local newspaper. The initial offending took place at a hotel. Bookings were made by the complainant's mother, Dell. Divine accompanied the complainant to the motel and stayed there while she was exploited by many, many men. And the earnings are then split between Dell and Divine. The complainant later provided some services from Divine's residence as well. And on another occasion, she was taken to a client's residence to perform these services. Case study 3 is from Western Australia. In this case, it involved prolonged abuse by the complainant's primary caregiver, being her father. This involved conduct that occurred across a 2-year period when the complainant was aged between 11 and 13 years old. In this case, we have her father posting classified advertisements online. In these ads, he presented himself as a single father of a female child seeking friendship. On other occasions, he responded to advertisements in the personal sections of these websites. He would connect in with other men, they would strike up a friendship, and they would speak about the complainant. Eventually, they would arrange meetings with the men, and this would be at various hotels. It would also occur at his and the complainant's home, and it would also occur at the residences of several of these men. Once they had arrived, he would then compel his daughter, the complainant, to provide the sexual services. At times, he would watch, direct, and encourage it, and at other times, he would participate in the offending itself. The offending in this matter in particular involved a high level of depravity and degradation of the complainant. It also involved unlawful and intimate images and recordings being taken of the complainant during the offending conduct. So if we go back to our elements, so we know that there are physical, fault, and jurisdictional elements. If we start with the physical elements, we know that there are 2 parts to this. The first is transport or movement of the complainant, and the second is that the complainant is under the age of 18. So when we're looking at transport or movement, in each of these cases, the complainant was moved. She was moved from her home to hotels. She was moved from her home to other men's residences, and she was moved from her home to Divine's residence on a few occasions in case studies 1 and 2. The second physical element, in both cases, the complainant was under the age of 18. And then if we look at the fault element, now this element requires that the offender intended or was reckless that the complainant would be used to provide sexual services or be otherwise exploited. It's clear that in both these cases, the offender intended that the complainant be so used. Then we move to the last element, the jurisdictional requirement. This is where it gets a little bit tricky. Because these case studies involved Tasmania and Western Australia, that is, it occurred within state borders, we can't rely on the exception that applies to territories. And so we must rely on one of the other requirements or exceptions. Here, we have relied on the requirement that says some of the offending conduct occurred via phone. So if we look at our case studies, in case studies 1 and 2, we have Dell making the bookings via phone. We also have a phone number being used in the advertisement that was placed in that Mercury newspaper to begin with. With respect to case study 3, we may have some phone use that's a little unclear right at the start. We might have the father using his phone to post the ads, respond to the ads, communicate with the men. But what we do know is that a phone was used later on in the piece to take the intimate images and recordings of the complainant. So that's how we say that these cases satisfy those physical, fault, and jurisdictional elements. The only other thing I'd note here for completeness is that the motivation for the offending in both these cases is a little different. In case studies 1 and 2, the motive was financial gain or it was a profit-making scheme. In case study 3, it was sexual gratification of the offender, of the father. And we see these 2 motives frequently in cases of this type, as well as other motives appearing from time to time.
So it sounds like child trafficking.
Yes, it does.
So why isn't it being charged or even recognised as child trafficking? Is it lack of awareness? Is it lack of training? What's going on?
So there are a few reasons for this, and each of them are very valid. The first is, as you would know, police discretion at the charge level. The second is prosecutorial discretion at the trial stage. We also have matters resolving to something other than child trafficking, and this is usually because of pre-trial negotiations, plea offers, things like that. We also have a desire to protect and promote the well-being of the child victim survivor by not making them a test case. So in circumstances where we've only ever had one recorded conviction of child trafficking, there's often a desire to not put the child through an area that's largely untested. And so there may be a preference for other more substantive offences like those state offences we spoke about previously. On top of this, it might be a failure to recognise or identify a situation as child trafficking. And I think that's due to historical misunderstandings or assumptions that are made. And the last reason that we see that this is happening is because of some limitations with the Australian definition, which we'll touch on a bit later. But what this is meaning is that perhaps we've got situations where some of the offending conduct falls within the umbrella of child trafficking and some of the offending conduct might not. And so out of a desire not to fragment proceedings like this, there's a preference sometimes for a substantive charge that covers the offending conduct without trying to tear something apart like that. And so they're the reasons we're seeing.
David, I might bring you into this now, if that's okay. So you're saying that these examples in the report are examples of child trafficking in Australia. So having read the paper, I know it's pretty complicated, especially here. Can you talk us through what that is?
Yeah, so we started today's discussion talking about United Nations and also the Criminal Code of Australia. And so this is one of the kind of challenges that we're seeing. So I'll preface this by saying that ZOE works in 5 countries. We've worked with government and law enforcement from all over the world, met some incredible people through that. And I would just have to say that no country has this figured out. Yeah. So this is still new. There's emerging trends. And so I think we're all learning together in this space. When I look at these cases that we've identified in the report, I would say that if we had these cases in America or in Thailand, these would be child trafficking cases and would be prosecuted that way. I think we would say it's arguable that these would also be trafficking-based cases here in Australia. Yes. I think one of our challenges is around movement. Yes. And so there's a narrow focus or a reliance on transportation. And so this is one of the things that is on the Attorney General's radar. It's part of discussions around the targeted review, and we're very thankful for the work that's being done in this space. But it has been something that's been highlighted by other nations of the world. It was highlighted in the Trafficking of Persons report from the US government about this restriction and this narrowness and reliance on movement. But I think that makes it a bit of a challenge. When we look at the wording, it talks about organises or facilitates the transportation of another person from one place in Australia to another place in Australia. And so movement is a key part of that. And as Gabby talked about earlier, this additional jurisdictional requirement adds some extra complexity. And Gabby did touch on this, but there is some wording within it that says transportation across state borders or within a territory. So when we look at that wording, we could get a different legal outcome based on where the offending happened. And then obviously, as we've touched on already, the use of a telephonic service is another part that has to be proven when it comes to domestic. So I think the focus on transport, the focus on movement, we could argue the overfocus on these parts has the potential to limit other parts of the crime. And I mean, an easy one to pull out in some of these cases would be things like recruitment. So the person that was involved in the recruiting may not have transported. And so that's where it gets a little bit harder. And these are some of the nuances in the law, which is why we brought a barrister to the conversation to help you and I out, Warren.
Well, I was just going to say, isn't it fortunate we have Gabby here?
Yes, that's right. Yeah.
And also as part of the team ongoing, because I know this has been a something that's been in the making for many
Yep.
years, and lots of people have been involved.
Definitely.
Gabby, I just want to ask you more of a specific question around that movement
Yeah.
piece. So how does that narrow focus on movement limit who or what gets captured under the current laws?
Yeah, so the issue we have is that this narrow focus on movement in the current Australian definition means that the actions of some others in the exploitation chain more broadly might not be captured or might be excluded under the domestic child trafficking definition. So if we go back to our case studies for now, and we'll talk through this a little bit. In case studies 1 and 2, we have Dell, the mother. She is the one who made the bookings, but she did not accompany the complainant to the hotel, and she did not transport her there on the facts as we understand them. So her actions in advertising, soliciting, recruiting the complainant wouldn't be captured within the definition of Australian child trafficking. If we now look at case study number 3, a significant portion of that offending conduct occurred at the complainant and the offender's home. So we have a situation where that conduct wouldn't be captured because there's been no movement of the complainant from place to place. So the conduct that occurred at the hotels and the conduct that occurred at some of the client's residences would be captured, but the things that occurred at their home wouldn't be. So we have that fragmentation where we have some conduct falling within the Australian definition and some conduct falling outside, even though all of that conduct would fall within the broader international definition, which, as David said, includes things such as receiving a child, recruiting a child, harbouring a child, which captures more conduct in that broader exploitation chain.
And interestingly, in both of those cases you referenced, it involved trafficking conducted by parents. Is that what we're seeing in Australia, or is it more complex than that?
Yeah, so sometimes definitely we've seen trafficking occurring within or connected to a family unit. In case study number 4, though, we've got a slightly different situation. In that case study, which is taken from New South Wales, the offender is 23 years old. He's also somebody that is having an ongoing sexual relationship with the complainant. And so I guess what we're seeing, and the point of this is that modern slavery, modern child trafficking is not necessarily taking the form that it has traditionally, and it's challenging those traditional understandings and assumptions. No longer is the perpetrator just the stereotypical old scary man. We're also seeing younger adults as perpetrators, and we're particularly seeing this in the context of residential or out-of-home care. The other newer and more emerging form of trafficking that we are seeing is that of online exploitation or virtual trafficking. And that's a space that we've discussed, much more work and research is needed in that space particularly. But we're seeing this take a few forms in the modern day context in Australia.
Yeah, and I might just jump in there.
Yeah.
I think that's one of the challenges sometimes is that it can overlap
Yes.
with other, and we have work that's being done by the Australian Centre to Combat Child Exploitation, work that's being done in other sectors, and sometimes even in the National Action Plan, it talks about this crime intersecting with other crimes. And so it's hard to sometimes see it and work out where is the overlap and what penalty should be charged and where it sits in the criminal code, which adds just a little bit more complexity.
Yeah.
Yes.
Well, the other thing I noticed too, that in the cases that was referenced in the paper, that the victim survivors were all female. Now, tell us a bit more about that. Is that the case? Is that what we're seeing?
Yeah, so that actually wasn't intentional. The sad reality is that both boys and girls can be victims of child trafficking. We know that boys and girls are trafficked for the purposes of sexual exploitation. We also know that boys can sometimes be trafficked for a particular purpose, such as participation in forced criminality. But the sad and stark reality is that child trafficking doesn't discriminate, and both boys and girls are at risk of being caught up in this type of offending.
So it just makes me think, right? With my experience in the past, charges are still being laid for some of these offences. Some of these offences still going to court, children still being removed from harm, and that type of thing. So why does it matter what we call it, David?
Yeah, it's a good question. Yeah. It's an insightful question, right? Why does it matter? And I think this is where the whole conversation today shifts. We're shifting now from a legal view across to what are the needs of the child. And so we're shifting the focus and we're saying, okay, we're putting the child at the centre of this conversation. And I think that's exactly what we need to do. At ZOE, we've worked alongside child survivors for many, many years. We have survivor advocates that will speak into our programs and help to continue us to be better informed. And we really want to continue to learn from people's lived experiences. I think that's really, really important. And so I think shifting the conversation now across to here is really important. This is probably my personal heartbeat that's going to come out through this part here. So why does it matter? It matters because unless we call something the right thing that it is, unless we classify cases correctly, then children may not get access to the specific help and the support that they need. And we need to make sure that we care for our children in our own country and ensure they get access to the best help available so that they can heal from trauma. And, you know, the question that keeps me up at night is today, if we identified a child from a trafficking situation, where would they go? Sorry for getting emotional. It's deep in my heart. When I talk about children, it's very personal to me. And so right now, if a child was removed from harm, they would go into some form of emergency accommodation. So that could be an alternative care arrangement. It could be a contingency care placement. Often that means that they can't go into foster care because foster carers aren't equipped to help a child from this level of trauma. So they often will be placed somewhere temporary in emergency, and that could mean a hotel. So if we just pause for a second in the conversation, we've talked about offending that's happened at a hotel, children being taken and dropped off at hotels where they've been exploited. And now we take that child and we place them, after removing them from harm, in a hotel room. And we have people go and supervise them that are doing the best they can, but there are reports of some of those people being untrained and they're supervising a child. So if you think about what that's like for that child, they're in an unfamiliar environment, a place that may have been the place where they have been exploited and abused. And every 30 minutes, every 40 minutes, someone comes around and knocks on their door to check up on them, to make sure they're okay. But if we really start thinking about that, how much could we be re-traumatizing that child as soon as we're removing them from harm? And that's a hard place to sit.
And thank goodness for people like you, David, in this world, because, you know, I think back to the many cases I've investigated, you know, we had 12 investigators, 500 cases plus a year. And how many of those that I actually didn't think about because they became a number, right? Because we were just doing our job. And so we would have, you know, have the initial contact and then put them in a hotel sometimes, right? But what if there's no hotel? What happens to them then?
Yeah, so the hope is obviously to provide safe place for children, so safe and supported accommodation, somewhere for them to go. I think one of the really hard things as we sit here today in Australia is that we continue to see the number of foster carers drop in our country. So there's less options available and we're seeing more and more children placed in residential care. And that's a really hard place to sit. And again, I just want to be really clear with my words is that we are not sitting in judgment here today. There is a lot of good people that are working very hard to try and care for children and protect children. But at the same time, you know, residential care was never designed to help a child who was a victim survivor of child trafficking or slavery. It wasn't designed with that in mind. And this is where I'd go back to the United Nations Special Rapporteur who spoke about this also. So I've shared some of her findings before, but she also shared anecdotal evidence of trafficking of children from residential care homes or from residential homes for the purpose of sexual exploitation and transactional sex. And so this is where it gets quite challenging when we're thinking about where do the kids go if we're putting them in an environment that the United Nations is saying, oh, that may not be the best environment for a child, let alone a child who's had significant trauma. And we have seen that residential care has not produced great outcomes for children, especially for children who have had profound trauma. And so why does classification matter? You know, why does it matter? It matters because correct classification leads to specialised care for children. And that's the most important thing.
David, thank you so much for bringing that human element back into it, you know, because quite easy we can just get caught up in the numbers. Yeah. So it's really important that we do focus on each individual child, right?
Yeah, and I'll jump in one more bit just here, because I think that over our work over many years, we have seen children heal from trauma. But it's taken significant resources. It really has. It's taken a long-term view. It's not a 60 or 90-day program. We're talking about a child, and we're talking about stepping alongside them on a very, very long-term journey. And so it really needs to be really well considered. And I know there's great people on the call that do this work, but it's really important. It's really important. We owe this to our kids. And I love what you shared before, Gabby, like, these are Australian children, and this is in our country, and so there's a shared responsibility here for all of us in this.
And you can see why people don't want to see it from a human level, because I can see the emotion in you, and it wells up in me when I think about it too, right? So we're going to move away from that a little bit, so we can gather ourselves. Might throw it to Gabby. So David's talked about the care and recovery aspect of it, right? So why else does classification, why else does it matter?
Yeah, so we have a section in the paper that talks about this in a bit more detail. Classification and correct classification will also help strengthen Australia's modern day slavery laws. Correct classification will also ensure that stories are no longer being suppressed. Misclassification deprives the child victim survivor of the language needed to fully express, convey, describe, give voice to their experience. Correct classification also matters because it's through increased understanding that we get better and more targeted prevention efforts. And just on a personal note myself, I feel a deep moral responsibility to not just listen and hold space for these stories, but to ensure that they are being recognised and named what they are. And so that's my why, I guess.
Thank you.
Yeah, and I think I'll jump in again.
Yeah,
sorry, Woon. Because I think with our work globally, we've learnt so much. And if I think about what we've learnt in Mexico, as we're identifying and hearing more stories, it helps feed into prevention programs. We do the same in Thailand. We're learning more stories of children. We're learning about how those that want to exploit children, they change tactic, they morph very quickly. And so as we're learning more and more, then we can feed that into very specific targeted prevention programs, and we can do those at age appropriate levels. And that's very important. We are unfortunately needing to do age appropriate things for children who are younger and younger. And I think this is part of the misconception around child trafficking. You know, it's just old teenage children, but that's not actually what we're seeing. There's also younger victim survivors that need help. So the better we can understand and build this classification, we can learn so much as a sector. And we've got great channels set up already to do prevention. But how do we learn other things and put that into great prevention programs? Because, I mean, I'd love to not ever need to do restorative care. I'd love it that we never needed to prosecute. I mean, call me a dreamer. You know, more and more we see as we talk with law enforcement that there is so much need for more community involvement, and prevention's key. Safe and trusting adults in our community keep children and families safe. So how do we empower those people with really good information so they can see and identify things in their community? The burden can't fall on law enforcement, right? They are wonderful. We love them. We appreciate them. Yes. We do. I think law enforcement do an incredible job. And if you're if you're listening to this and you are in law enforcement, we personally cannot thank you enough for all that you do. I feel like law enforcement does some of the hardest work imaginable, and they seldom get to sit on the side that I've got to see, seeing children heal from trauma and seeing a child go on that journey towards healing and restoration is the greatest privilege that you will ever have. And it can happen.
Yeah.
You know, kids can heal. Kids can heal from trauma. It starts with law enforcement. It starts with, prevention. Oh,
Yeah.
there's work to be done.
And
There's work to be
I
done.
hear that when you're speaking. And I think the heart is, we hope that ZOE wouldn't exist in the future.
Yeah.
There'd be no need for you. Yeah. Because it wouldn't be happening in the first place.
So true.
And I think about policing as well, you know, at the heart of policing, it's about proactive prevention as well. We don't want to be enforcing the law, you know, we want to be working with the community to stop crimes from being committed. And so it's the same, right?
Yep, absolutely.
So I think it's a really good time to maybe bring in our audience because we're getting some really good questions. So one of them is, would classifying these cases as trafficking result in harsher legal penalties for the offender?
So you want to do
That's
this
a
one?
legal one.
Yeah. I have an opinion.
That's right.
I think the answer is one of those annoying legal answers, which is it depends. It depends where the offender's located. It depends on what we're comparing it to, right? So child trafficking versus a CAM offence, absolutely, it would result in harsher penalties. Child trafficking versus people in the exploitation chain who fall completely outside the law, such as, say, Fidel, the mother, her activities in recruiting, advertising, soliciting, if that falls into a kind of space that we can't pin her down for a penetrative offence, for example, then absolutely child trafficking would. Certain offences, maybe not in the actual figure amount or year amount. If we're talking about penetrative offences, they're a high, max penalty comes with those across Australia. So it really depends what we're comparing it to. And, within that discussion more broadly is, a whole other can of worms about justice needs and about what we're focusing on. And if we're focusing on punishment, maybe we'd get a better outcome, maybe we wouldn't. But there are a whole other reasons or justice needs or considerations that we would think about as well.
It's a good answer. I'm not even going to add to it.
Really?
Yeah.
I was going to throw it to you actually,
Well,
but you made me think about a case that I was involved in personally, and in the end we did get it to court, and in the end we didn't get the guilty result, right? And then one thing that's always stuck with me, this particular girl, we embraced each other and we cried in each other's arms at the end after the court case, and I said, I'm really sorry I didn't get the result that you wanted. And she said to me, I'm going to be tearing myself, she said to me, the result I wanted was for somebody to believe me.
Yeah.
And I'm like, oh.
Yeah. And I think that's where, I respect the question, but the justice and the punitive side is important, but it's one aspect.
Yeah.
For me and for ZOE, and I'm sorry, Gabby, you're the barrister, but for us, the higher goal is to ensure that that child gets the support they need. So I would, justice is important.
Yes.
Harsher penalties are important. And I would talk about our work in overseas.
Yes.
I would say that as crimes were categorised correctly and as these crimes went through the criminal justice system, it actually sent a message to the whole sector that the government was serious about it. Law enforcement was serious, and it actually has a significant flow-on effect that's very hard to measure. Yeah. But the more these cases go through, people in Australia will realise, oh, hang on a minute, this is something we take seriously. There is a penalty, justice will be served, but ultimately...
Talking about deterrence there.
Yes, correct, deterrence, 100%. Yeah.
So this is interesting because the case that I'm referencing, it was a good news story. Went to foster care, well cared for. I actually know her now, and she's a full, healthy human being doing very well for herself. But unfortunately, I think that's an exception. Yeah, I don't think that it happens. And I think, I think it feels like we need more processes in place so that, when we don't have that connection with that one, that there are things that happen, because the system's set up for it. I feel like it needs to be like that. Yeah. Look, we've got another question here. So it reads, so is this the definition of the law, a deliberate act that is set up this way, or just not thought about well enough at the time? And is the delay in getting it rectified a case of slow public sector?
Oh, well, I don't know if we need to get into the reasons why, because I think the people on the call are great people doing good work, and I think changing law takes time. And I think there was a US president that said you never take down a fence until you realise all the reasons the fences were put up in the first place. And I think there's some wisdom in that. I think that when we look at the way, there's potentially a worldview around trafficking, that it is about an international perimeter. And but the legislation does allow for domestic child trafficking. And so, there are situations where, let's say, a child was trafficked internationally. So started internationally, there's a case of someone from Indonesia that came to Australia, and that person could be tried for trafficking, but then someone met them locally and drove them 3 streets. And so I think sometimes we're connecting it to the origin of the person. So where did they begin internationally? But I think that what we're trying to show through the paper is that there is legal provisions around domestic child trafficking. There are some nuances, but I think this is something that can be looked at in Australia.
Yeah, can I just add, I think to the person who asked that question, they're spot on. The paper talks in the law section about the explanatory memorandum that accompanied the introduction of Division 271 back in 2005. And there's a bit of language in that we've quoted in the paper where I think understandings have changed in the 20 years since that provision was introduced. There was a comment made that it criminalizes every aspect of the exploitation chain. And I don't think that holds true anymore. And I do think that there was an over-reliance on children being brought here, and maybe an unwillingness or we weren't quite ready to accept that it's happening within our borders. And so the paper does talk about that a little bit, but I think, as times change, we're 20 years down the track, there's definitely appetite there for law change, and we've contributed to the targeted review, and so I think this is on the Attorney General's radar, and it will be interesting to see what happens in this space.
And it is a learning space. Like, it is a learning space. The Australian government has made changes to the criminal code. There's been additional provisions put in around crimes such as forced marriage. And I look at what has happened in that space and how much work's been done in the forced marriage space, and I absolutely applaud the work that's been done. I mean, we've now created specific support services for those impacted by forced marriage. There is training through Look a Little Deeper. There's a separate module that the Australian Federal Police have that talks specifically about that crime type. We now have an additional referral pathway specifically for that. So we're all learning. We are learning, and I think it takes conversations like this to think, okay, how do we progress and what's the next steps?
And so what's great about listening to you again, every time you two speak, it becomes clearer to me. Really, what I'm hearing is that reclassification is so important. One, because it makes sure that the child survivors don't slip through the gaps. And the other one is too that, perpetrators or offenders are held to account. So currently, if they bring them in from Australia, they get held to account, but the ones that are moving within Australia or within states aren't.
So it could be the crime type could be caught. We know that crimes against children are harder to find, and they are harder. There's certain crimes that get done against children that could have 15, 20, 30 years before the person is ready to share their story. So crimes against children are not easy to begin with. Children don't have the same voice as an adult. They don't have the same agency. We're talking about things in a familiar-based setting. Very, very difficult for a child to reach out and get help in that. So there's a lot of complex parts that specifically helping a child and identifying a child is already harder, which is why we need this community aspect to help us.
This is so good. I'm getting light bulb moments when you're speaking, because the majority of the cases that I investigated were classified as historical, and sometimes years and years. And so what Zoe's trying to do, what the two of you and the team are trying to do, is create that awareness. So maybe we can be more aware so that of it sooner, so that we can provide services sooner. So that's great. So we've got another question here. So what are your recommendations around support and care structures for child survivors of child trafficking in Australia?
Well, I think we need to go on a journey together. There's great people on the call today, and say, well, what would be the unique needs of a child who was rescued or removed from harm or recovered, depending on what is the correct terminology to use there. And how could we ensure that they were cared for in a therapeutic way so that we could go on a journey to help them heal from trauma? So it's outside today's webinar. That's a whole nother conversation about what restorative care could look like.
Yeah.
But we have a lot of learning. There's international learning in this space. We have learning from ZOE. And just to be very clear, we are not promoting that ZOE can solve all of the problems. This is going to take a community of people working together. We have ideas about what restorative care would look like and how we could do that in a way that would really support a child in a family or home-based setting and surround them with very, very skilled people that would help that child to heal. We know from research that children heal through safe and loving and trusting and supportive relationships. We know that you can rewire the brain.
Yes.
We know that the trauma that a child suffered is not permanent, but it does take consistency. It does take long-term view, and it's not something that generally could happen in a 60 to 90 day timeframe. So it's going to take a consistent effort. So if there's people on the call that want to have a conversation with us about that, I would love that conversation. That's what we dream of, right? Creating these sorts of programs in Australia like what we have overseas.
Yeah, absolutely. Well, David, strap your boots in, mate, because I reckon this is not going to be the first or last webinar that you'll do. But we do have a question directly for Gabby. So, Gabby, what sort of education and cultural changes are needed within the legal profession to ensure a better understanding of how these cases need to be classified and ultimately prosecuted?
Tricky question.
Yeah, and you've only got one.
Yeah, it's a big question. Yeah. I think firstly, you've nailed it with the education piece. This is a conversation that we've been having for a while now, but even speaking about it with you, it's challenging perhaps understandings, assumptions, where your mind would immediately go when a child comes to you and makes a disclosure. So I think there's a real education and conversation piece to have with law enforcement and prosecutorial bodies across Australia at both the state and federal level. Separate to that, I think something that, it's what I touched on before, that even with this education piece, we are not necessarily saying that every case needs to be charged and prosecuted as child trafficking. And there are many reasons why it won't, and there are many good reasons why it won't or can't. And there's some of those other things that we spoke about, plea negotiations, not making children test cases, trying to minimize trauma in the legal justice system, cases falling both inside and outside the current definition. So even if everybody was educated, aware, completely cognizant of this, there are still legal challenges and hurdles that mean that we might not proceed with a charge and prosecution for child trafficking. One of the things that we've been speaking about is perhaps working more closely with law enforcement and prosecutorial bodies to get improved data or more accurate data in this space. So right now, the only, specific piece of data for child trafficking in Australia is that conviction rate, and we've got a case of 1. And so one of the things we've been talking about is whether we can work with law enforcement and prosecutorial bodies to create some kind of flagging tool for the purposes of better of getting more accurate and more up-to-date data on what the prevalence of child trafficking is in Australia, even if charges and prosecutions aren't proceeded with. And in our view, that would have many flow-on effects in terms of funding, prevention, identifying children, all of those things. So there's definitely work to do for law enforcement and prosecutorial bodies, and we're very encouraged to have so many of them with us today. And again, we're very keen to hear from you and learn from you as well.
Yeah, so that's what I'm actually hearing, that sometimes law can take time to change, but there's things that we can do now. Yeah, so that's great. Another question, in the paper, you speak to language being used as a tool for justice. Can you please explain how we can do this in practice?
Yeah, so a part of the paper includes some commentary on some of the language that appears in either the legislation across Australia or the cases that we have spotlighted in the paper. in my own view, and I think this is a shared view, for those of us working in this space, we have a real responsibility to make sure that the language we're using is trauma informed and always gives dignity to the child victim survivor. So, for example, some of the things we speak about in the paper that we think is unhelpful is calling child trafficking child pornography, calling, child prostitution,
Sure. Yep.
and referring to children involved in this as prostitutes or child prostitutes. Another thing that we found really difficult was when these kinds of arrangements were referred to as a relationship, or when we are imposing consent on very young children. In some of the cases, they speak about discussions occurring and the children agreeing to be a part of this arrangement. And I think whilst we can give dignity and agency to children victim survivors, speaking about this in terms of an agreement completely undermines the trust-based relationship that they're in, the exploitation that they're experiencing, and the lack of agency they have in moments like that. And so for us, it's really important. Another one of those language pieces for us is around the term victim survivor and really giving dignity to people who have lived through this. And yeah, that's very significant for us.
I think, we would always maintain that no child can consent to their own abuse.
Yeah.
So any language that's anything different to that, we would take
Reject,
pretty strong.
Yeah.
We would feel very strong because we're talking about children.
Yeah.
So I think we've got to be really careful with our language around that. And any language in any of this that's talking about consent, like the child agreed or the three of them arranged to, and it almost has an implied that, oh, well, you just had a conversation like you were saying, hey, where are we going to go for dinner?
Yes.
Oh, well, we all agreed. This is not what we're talking about. No child can consent to their own abuse.
Yeah.
So that has to be very clear across the sector.
Yeah.
And I think we're doing better in Australia. We've really improved language over time. I think that's really great. And I think this is more of an encouragement. Let's keep improving things so that we are getting, we're really thinking about the needs of the victim survivor, that person, that child, that individual person.
So we have time for one more question, and it's a good one. So what are some short-term or meaningful first steps we can take? Either of you?
One of them is further research, further work in this space. This is just paper one. There's work to be done on virtual trafficking. There's more work to be done on building up these numbers. These are 5 case studies. There's much more work to be done there. There's work to be done with engaging and liaising with stakeholders and furthering this conversation. And the other really short-term win that we thought could happen to try and improve the data in this space, and I'm just pulling up the section, is there are some state-based child prostitution or child sexual services provisions. And our thoughts are that including the convictions under those into the child trafficking numbers would start to give us a better idea of its prevalence. And so that's just a data piece rather than necessarily law change that we're talking about there.
Yeah, so there we're talking about the crime has already been prosecuted, and we get that referral somehow or that data caught so that we have more realistic data of what's happening, even if it hasn't gone through a full judicial process, specifically around 271.7. So I think there's a lot that can be done. These are short and medium term ones. I think there's a lot of conversations around training about talking about this at both a state-based policing level as well as a federal, because this crime is, we're talking about federal legislation, but most of these crimes are caught at a state-based level when it's a domestic case. So what else can we do within state-based police to try and help them see and identify these kinds of cases? But before we jump off, I did want to just say just a huge thank you to all the people who are on the call today. When we started this conversation, and I will pass back to you in a second, Woon, we have been inundated with people from all over Australia who wanted to join in this conversation, and we're incredibly encouraged and very thankful to all of you for joining today. I won't go through everyone, but we definitely have members from the Australian Federal Police, from the Attorney General's Department, the E-Safety Commissioner, anti-trafficking and human rights organisations, from the Catholic Church, from IJM, from Walk Free Foundation, from great people that are working so well in Australia, from the Australian Red Cross to Anti-Slavery Australia, Salvation Army. Anti-Slavery Commissioners Department, the Australian Institute of Criminology. I mean, this is incredible that they would give their time to this. And obviously we've got Victoria Police, New South Wales Police and other police across, people from the family violence sector, child protection. We're very thankful for all you do. It's a very hard job you do. And we have child protection officers and personnel from many states in Australia. We've got legal professionals. We've got some barristers on the call today. We've got different educational institutions and universities that have come into this call. We've got the Commissioner for Children and Young People, and then so many local-based community services. So, you know, when you think about who's on the call, we're greatly encouraged because I think there's people here that can make an incredible difference. And if we start having these conversations together, wow.
Yeah.
Imagine what we can do.
Yeah, it's incredible, isn't it?
Yes.
Yeah, yeah. It's really encouraging that so many people have been able to log in today.
Yes.
Yeah. And I hope that this becomes a resource for others in the future that they can access as well. And I'll give some information on that. So, you know, in closing, I just want to pause and reflect on some of the powerful stories and statistics and solutions that we've heard about today. And child trafficking isn't just a distant issue. It's happening here in Australia and in our communities. And facing that reality means taking collective responsibility to do something about it. I want to acknowledge the lived experience of those joining us today. And if any part of this conversation has been distressing, please know it's okay to step back and seek support where needed. What we've explored today isn't just research, it's a call to action. It points to cracks in our legal systems, gaps in our data, and the urgent need for survivor-centred care. Misclassification isn't just a technical issue. It's something that can deny truth, delay justice, and prolong harm. We've heard from Gabrielle and David, so thank you, from you too, about the important work already underway, shedding light on these injustices and advocating for meaningful change. But the question remains, what role will you play? And so as you leave today, I invite you to sit with that and with what you've heard, reflect, talk about it. Please share the paper and consider how it might contribute, whether that's by raising awareness, supporting survivor-led efforts, pushing for reform, or simply keeping this conversation going in your circles. So thank you, David, and thank you, Gabrielle, for your incredible work, and to each of you for being part of this important moment. And for everyone else, you can download the full report at gozoe.org.au. So I'll go with that again. It's gozoe.org.au. And I'll just leave you with a couple of thoughts. Together, we can shift from awareness to action, from silence to voice, and from injustice to hope. For every child whose story remains untold, let's speak, act, and advocate until they are seen, heard, and protected. And lastly, justice doesn't begin in the courtroom. It begins the moment we refuse to stay silent about what we know to be true. Thank you. Thank you, everyone.
Thank you, Aaron.